We have a fairly large docket, and we have 1 hour and 5 minutes to get through it. I've got a hard break in an hour to chair another committee. So let's get on it. Senator Dance, you had a bill.
Yes, sir.
Right. Oh, I'm sorry. Clerk, call the roll.
Four, five, six, seven. Where there? Oh.
Yeah.
Okay.
All right,
Mr. Chair, you have a quorum.
Okay. Thank you. Senator Dance, your bill.
Thank you, Mr. Chairman. I have a substitute.
Okay. There's a motion on a substitute. Okay, it's been moved and seconded to substitute to Senate Bill 253 be adopted. All those in favor say aye. Aye. Any opposed? Okay, Senator Dance, substitutes before us.
Thank you. Senate Bill 253, as presented in the substitute, represents peace in the valley between the Virginia Bankers Association and the Department of Treasury. This bill clarifies the ability of banks to refund dormant account fees to their customers, and after discussions between the Bankers Association and the Department of the Treasury, they agreed through the substitute that the concerns that they had as far as the money distribution satisfied. The substitute clarifies that banks can refund dormant account fees, but must do so in a consistent manner, including accounts reverted to state as unclaimed property. I'm sorry, could you all hear me?
Yeah.
Okay, sorry. You want me to start all over again, or can I keep going?
No, you got it. We heard you.
Okay. This bill provides banks the clarity they sought to charge dormant account fees and the option to refund them to customers who request them, while making sure unclaimed property accounts held by the Commonwealth are treated the same as customers walking into a branch. As I said, this bill has reached peace in the valley, and the companion bill to it, carried by Delegate Margaret Ransom, has passed the House 98 to none. Evidently two wasn't there.
All right.
And you have it in the bosom of the Commerce and Labor.
All right. Are there questions for the patron? Is there anyone opposed to this legislation? Okay, it's been moved and seconded. The amendment in nature substitute to Senate Bill 253 be reported. Clerk, open the rolls.
Do I get to vote up here?
Oh, sorry. Yes, ma'am.
You got it?
For some reason, mine, I push and I get nothing, so.
If you want his push, is that right?
All right. Ayes 9, no 0.
Okay.
Thank you.
Did you get that, Hobie? I'm pushing, nothing's happening. All right. Who's next? Senator Peterson.
Yes, sir. Mr. Chair, members of the committee, this is Senate Bill 16. And by the way, I'm going to make a pledge after this year to carry no more legislation dealing with the word freeze in it. So
Okay, all right,
this
let
will be the
me
last
make
one.
an announcement, because we have 6 freeze bills. I think Senator Favola is going to introduce a substitute that takes the 10, we reduce it to $5, okay? And $5 is, I have a bill, and we seem to have pretty broad acceptance on 5, Senator Sproul, but if you want to resist that, we can take your bill up right now. But I think we all understand what the issue is, and it seems to be an artful compromise, and I understand from our Frank Munyon that she has taken a substitute that had passed the House at $5, and I'm up for $5 on my bill. And you clearly, by the look on
Do I
your
hear
face, are not
$2.50?
up for $5. So,
Mr. Chairman,
Senator Black.
would it be appropriate to roll all of the bills together?
It would be. I just want to hear what Senator Peterson has to say.
You know what? I don't want to bore your time, other than saying nobody signs up to have a credit report, to have a credit history. It's something that is done to you, and of course, the lenders are the ones that benefit from it, and they're the ones that make money from it. So I don't know why you should have to pay anything to suspend it when there's some false information out there. I'd like to see 0. But that may be a floor speech, so anyway.
All right. Would you take 5 as a compromise and be part of it? Enroll, rename, and be one of the chief co-patrons, or do you want us to vote this straight up and
You
down?
know what? On this issue, I'll be your puppet. How about that? To
What's that mean?
I'll be I mean, you do whatever you want.
Okay, all right, all right.
Mr. Chairman,
Can I get, let me get Senator McPike up here because he has one too. Are you all right with the roll? Okay, all right. All right, so right now, Senator
Mr. Chairman.
Spruill wants to roll. Okay, Senator McPike, Senator Peterson, Senator Surville. So far, everybody wants to roll from $10 to $5 on the security freezes.
Right, only one of my security freeze bills, the other one's.
Okay, the other one's a little different. Okay, all right. And then that's mine, that does them all. So for purposes of this, and I assume that Frank was saying that Senator Favola was right with it, so that's going to be Senate Bill 62, 38, 22, 18, 16, and my bill 659 rolled into one bill. Who wants to be chief co-patron? I mean, who wants to be name at the top and run over to the House with
You
this?
know, I have so few bills coming over that you might as well.
Senator Peterson, just because we're gonna give you that motion. Okay. Do I hear a motion to roll all those bills together? Clerk, open the rolls. Okay, clerk, open the rolls. Okay, those bills have all been rolled together, and do I have a motion to report? Okay, these bills are, 16 will be the lead bill, okay? Okay, and we know it's 16, 18, 22, 62, and 659. Okay. Oh, and 38, I'm sorry, 38. No, 95 is a little different. We'll have to take that up, okay? All right, now we understand. Clerk, open the rolls. Okay. Moving away, Senator Surville, let's hear about 95. Clerk, close the roll. Mine is not reporting, Hobie. Okay, all right.
Yeah.
Where's your one?
We have a substitute for that, Mr. Chairman.
I think it's been rolled. Okay. Yeah, we rolled it. Is there a motion on the substitute to Senate Bill 95? Been moved and seconded that the substitute be agreed to. All those in favor say aye. Any opposed? Okay, the substitute's for Senator
Thank you,
Surville.
Mr. Chairman. This is pretty quick. This is just a sort of a technical lawyer type cleanup. I had a colleague who was trying to get a security freeze and ran into a headache with one of these credit companies because the current code only allows them to provide a power of attorney for a child, and children can't sign powers of attorney. So there needs to be other documents that you can use to validate that you're the right person to ask on behalf of the kid. So we've added here a birth certificate or a written notarized statement. I went over this language with the credit bureaus. I think Mr. Helm is here, and I think they're okay with the language the way it is right now. And that's basically what it does, just so parents can get their kids' credit frozen, because you can't do a power of attorney. That just doesn't exist for children.
Okay, are there any questions for the patron? Is there anyone opposed to this legislation? I'm seeing thumbs up in the back. Okay, committee operates by motion. Been moved and seconded that the amendment to nature substitute to Senate Bill 95 be reported. Clerk, open the rolls.
Ayes 12, no 0.
Okay, that bill's been reported.
Thank you. I got two others. I got a bunch of others. I don't know how you want to handle
Yeah,
those.
we'll deal those in a little bit. Hobie, I'm still not recording. Are you recording it? Okay. All right. Senator McPike, you got another bill? Yes, sir. 968.
Senate Bill 968, Mr. Chairman and members of the committee, seeks to add some additional options for the Virginia Employment Commission when dealing with wage misclassification. When dealing with contractors, currently you have a $75 fee that can get tacked on based on reports, but there are still, frankly, fly-by-night contractors and others that are hiring folks as independent contractors when they're really employees of the company. And so therefore they're foregoing the unemployment, other wages and things that they should be paying in Virginia, so they're not paying their fair share. And that's really a part of the issue. Last year, there were roughly 8,000 noted cases based on review and analysis of filings and audits that are getting misclassified. So those are, part of the unemployment compensation that should be coming back to Virginia, that's not. This is, hurting part of our program. And this helps us to stiffen this up a little bit and give the Virginia Employment Commission a little bit more ability and tools in the toolbox to bring enforcement.
Okay. Senator McPike, did the VEC bring this to you, this bill?
Yes, in discussion, I believe there should be a representative here as well on some of the challenges. There's a 2017 audit and report they went through and identifying some of these findings.
Okay. All right, can I hear from the VEC? Is there anyone from the VEC here?
No? Sorry, Mr. Chairman, I thought the person was supposed to be here
Okay.
this afternoon.
I mean, it's some pretty serious fines, $1,000 each offense. Is there anyone opposed to this legislation?
Mr. Chairman,
Yeah, Senator Black.
Mr. Chairman, I don't have the full bill in front of me, but it says is liable to a penalty of $1,000. You're not, are you talking about $1,000 or not greater than, no greater than $1,000?
It says a penalty of $1,000 for the offenses arising under Section B of the existing law.
For
Okay,
each-
so
for- that'd be for each offense, Senator Black.
So, Mr. Chairman, then there would not be the option to say, well, this was not done with any great malice and.
There's still due process under the next section, Section D.
I guess the
different
question, though,
transactions,
could they say, well, this is not that serious, a particular incident, and, maybe we fine them $50 or $300 or whatever.
Mr. Chairman.
Not for this, but I think it's the Virginia Employment Commission flexibility when they know someone simply misfiled the paperwork versus clear abuse of a system where they're actually avoiding paying into what we all pay into. If you're an employer, you're paying into the system because you're doing the right thing. But there are folks who are doing the wrong thing, and therefore they're doing it on the cheap, and they're supposed to be playing into the unemployment system, and that hurts everybody.
Senator McPike, is this an agency bill? Did the agency bring you this bill and
It's-
to ask you to put it
The
in?
administration supports this bill.
No, did
and
the
I'm not sure-
agency ask you to put this bill in? That's the question I'm asking, Senator McPike. Because if they did, I'm shocked they're not here.
No, in terms of the support, we've collaborated on the discussion of the bill, and they're supportive of the bill,
All right.
Mr. Chairman.
All right.
Mr. Chairman,
I don't want to misrepresent
Senator
VCs
Stewart.
without them.
I don't mean to cut this short, but actually I do mean to cut this short. This is potentially fining people $1,000 for failure to file a report. It's just hard enough to do business today with all the paperwork and bureaucracy that you have to put up with. And now we're going to threaten them with a $1,000 fine. I find that offensive, and I would move to pass the bill by indefinitely.
It's been moved. Do I hear a second? It's been moved and seconded that the bill be passed by indefinitely.
Mr.
Any
Chairman,
discussion? Senator McPike.
I'll just close out is today, the incentive is essentially disincentive of $75. And so we really need to find a balance that has people to the table reasonably to pay in, because otherwise we're also paying it into the pool. So good employers are paying into that pool than an unemployment insurance, where you got bad actors that aren't. And I'd suggest to the committee that 75, maybe 1,000 is not the right, but I think 75 just isn't the same motivation that gives VEC the amount of tools in the toolbox to get their work done.
Senator
appreciate
McPike, the motion's been made to pass by indefinitely with a second. We do have an unemployment commission that meets once a quarter. I'm a member of that commission. We discuss all the issues involving with the unemployment trust fund and that type of thing. I'm going to refer this bill to that commission, okay, to hear from VEC, to get their thoughts on it if we need to enhance it, but this just seems like a bar too far at this point in time. And if we need to enhance the penalties to get better compliance, I think we can work out some modem with that. But you didn't see it, but they went and sat down when the motion was made, but you had half the business community lined up behind you.
I
And
feel them. I feel the presence, ever present.
And I don't think it was to hold up your campaign bumper sticker. So, all right, we have a motion properly supported to pass the bill by indefinitely. I will send a letter to VEC. Clerk, open the rolls.
Ayes 8, noes 5.
Okay,
Thank you, Mr. Chairman.
all right, that bill has passed. Okay, who else do we have out here? We got, I'm gonna take these before we get to coal ash. We're gonna save coal ash for the last, just so everybody knows. Senator Sasslaw, you got a bill?
Yeah, this is, I'll do it after.
Okay.
Go out.
Okay, I'll take it. All right, let me get that.
We missed a thing on mine that needs to be unwound and just unstruck two places on the one we just did. I don't know if you want to do that now or later on the floor.
Just do the floor amendment.
That's what I thought.
Okay, all right. Senator Sasslaw.
Mr. Chairman, this is Senate Bill 933. And as it was introduced, essentially the major thrust of the bill was that a pharmacy could not charge more for a particular drug to a person that walks in more than what it would be if they had a co-payment or what the cost of the drug normally would be. It was essentially to hold down the cost. Just give you, if you take a look in B, it says no provider or contract between a health carrier or its pharmacy benefits manager, and it goes on to authorize a carrier or require the pharmacy to collect or require an enrollee to make a co-payment for a covered prescription amount that exceeds, and it says the applicable co-payment, the cash price the enrollee would pay for the prescription drug if they purchased it without using the health plan. The provider contract, so between the health carrier and its pharmacy benefits manager, shall contain provisions, and this is what I think got added in the substitute, that will allow the pharmacist, if there's a cheaper alternative. Oh, yeah, we better move the substitute first.
Okay, it's been moved and seconded that Senate Bill 933, amendment nature substitute be adopted. All in favor say aye. Any opposed? Okay, substitute's before us. Okay, Senator Sasslaw.
If there's a more affordable drug, they can tell them about that. If there's a therapeutical equivalent, one that's equivalent therapeutically, but the same price or less, they can tell them about that. And they can offer and provide direct and limited delivery services to the enrollee as an ancillary service in accordance with existing law. A pharmacy also shall not be penalized by the pharmacy benefits manager or the carrier for discussing information or selling a more affordable alternative. So essentially, what this meant was you got a truce between the farm benefits managers people and the pharmacies, the drug companies themselves. I think I was close to that, pretty much described it. So there's apparently peace in the valley, and that's what brought this compromise about.
Okay. Are there questions for the patron? Does anyone wishes to speak in favor of the bill? Nope. People sat down. Is there anyone opposed to this legislation?
Second.
Been moved and seconded that the amendment nature substitute of Senate Bill 933 be reported. Clerk, open the rolls. Okay.
Ayes 14, no 0.
All right, that bill's reported. Thank you. Okay, let's do coal ash. We might as well get to it. Did Senator Servo? No, come on. All right. Let me describe the posture. We have Senator Chase has put in one coal ash bill. Senator Surville has managed to put in 6 bills that address coal ash for a total of 7 bills. The House has put every single coal ash bill into a study. directed by the Chairman Kilgore in the study. There are some actions that we'd like to be able to take to allow those utilities that have consolidated coal ash into a single pond to get the final permits to allow them to close the ponds that they have moved from. Would you agree with that, Senator Servo?
Yes.
Okay. Is there other action you'd like to take beyond that?
Yes.
Describe what that might be.
It's important that we continue the existing moratorium, number one, because the moratorium expires officially on May the 1st, 2018, in a couple months here. And if we're going to continue to gather information about this, that moratorium has to stay in place, or else all these ponds could have a rubber tarp put on them with dirt, and another $500 million gets spent, and the odds of us undoing that, I think, are remote. And before the Dominion does that to our ratepayers, I think we need more information. Secondly, the substitute that I had prepared also requires Dominion to go out and do our RFPs for coal ash recycling. And when they get those RFPs back, to provide them to you, Mr. Chairman, the Chairman of Commerce and Labor, so that we can all have clear information about exactly what the recycling companies propose these things will cost, so that we can have really clear information before we as a body make a policy choice about how to close these ponds, which eventually our ratepayers in Virginia will end up paying for. And it's at least going to be hundreds of millions of dollars, potentially billions. And I think before we make that policy decision, we need to have better information. And so those two things,
Okay.
three
All
things
right.
have to be done.
All right, I understand what you're saying. Let's hear from the utilities on the last two things. Is there anyone here representing the utilities? Mr. Murray.
Mr. Chairman, Bill Murray from Dominion Energy. This is sort of an agreement in concept. We are comfortable. We view it as very important for situations where the ash has been removed or is being removed from a pond to be consolidated into another pond on site, or in one instance where ash is already being recycled, that we'd be able to go ahead and move forward on getting the permits necessary so that those are not so that those ponds that used to have coal ash can be closed. So we appreciate the patrons' openness to that. With regard to the recycling, I do want to be clear that while we're happy to do an RFP, we're going to actively manage that RFP. Our experience with vendors is that sometimes, sort of the sales pitch from a vendor and the business plan is not critical. It's just the nature of life. We're going to carefully analyze those recitals. So we're not going to just simply, and if we need to work on language on the other side, we're happy to do that. We're not simply going to just transmit the bids that we receive. We'll do that, but we'll also overlay with that our analysis of the feasibility and what we find from looking at that. So I think of that as sort of developing a business plan for recycling, as we would with any prudent undertaking. And then, of course, in terms of any further study, that's your pleasure, and that's the committee's pleasure.
Part three of that, extending the moratorium.
That seems to be where things are headed. I would say this: it would be better to move forward with being able to close the ponds where the ash has been removed than having a moratorium for everything. So it's something we can live with as an overall concept.
I believe, hang on a minute, Senator Spruill. I believe I have a substitute prepared, do I not, that covers some of the things we just talked about in anticipation of what you might do, Senator Servo.
Your sub.
In the meantime, Senator Spruill had a question.
Yes, Mr. Chairman, the
Yeah,
RFP
distribute.
on that, I noticed that you can do that. So I want to know, is that passed on to the customer? Because most utilities now, I find now, if they do anything, they pass the customer on to the customer. So does this entail passing the fee on to the customers?
Senator Spruill, as I understand, we'll do the front end of the RFP. In other words, we'll take the bids, but until we receive further legislative guidance, we wouldn't move forward with actually issuing any contracts or anything like that. I think what we're being asked to do is find out how much would this cost, so that you all can make some decisions next year on is recycling something that you're interested in making the policy of the Commonwealth. So, but basically, we would take the bids but not act on them. We'd share that information in our analysis with you all on what the costs are.
Mr. Chairman, second question.
Senator Spruill.
Second question was, Senator Scott's survey said something about in 2 months, something closed down in two months. So if we continue, like the They put them all together like they did in the house. If we do that, then it's 2 months. Scott said something to expire in 2 months. How would that work? You follow me? You were saying something about this would expire in something 2 months.
I think what he's referring to, current law center's rule on a bill that you all passed last year said the DEQ could not issue any permits until May of 2018, which I think was basically contemplating if you all passed a bill this year. And as I understand what the senator is contemplating is to extend that for another year for ponds where there is ash, but for ponds where ash has been removed to allow us to move forward with closing those ponds.
You have a problem with that?
I think as part of an overall compromise, we view it as progress to be able to close out those ponds, and it would be right much permanent work. We are taking ash out of more ponds than we're having ash remaining in, so there would be a fair number of ponds we'd be able to close that way and move forward. So it's certainly a little more than half a loaf in that regard.
All right, let's get the substitute before so we have a working document. It's been moved and seconded, the substitute, we'll call it Senate Bill 807. Will be the document, Senator Servo. Okay, all those in favor say aye.
Aye.
Any opposed? Okay, knowing that we're going to have a study, I'd like to have everybody draw the committee's attention to the very last 2 pages. It calls for that study. We have exceeded the time allotted by rules for a study, so I can set the study up by rule. So I'd ask that for everything from line 636 to the end of it be stricken, and I'd so entertain a motion for that. Been moved and seconded that 6 be removed, lines 636 to the end of the bill. All those in favor say aye.
Aye.
Any opposed? Okay, my understanding is that on from 630 to 635, those lines would allow where we moved coal ash out of existing ponds for those to be closed under permit, but would also extend the moratorium for another year. Do I read that paragraph 5 right? Does that accomplish that? 630 to 635. Does that do both of those functions?
No, that's got the concept there. I will say, Senator, that there are a great number of lawyers involved who probably would want to add more words at some stage of the process, but it's clear on the intent there. And of course, we have no view on the study. That's you all's pleasure.
I understand.
Okay. We're happy to do the recycling work that was contemplated.
Okay. I don't think 4 needs to be in there. Section 4.
Yeah, Mr. Chairman, I don't know if you looked at the sub that I handed you on the floor, but paragraph 5 is the only thing they had in common. The rest of the bill was not what at least I've been talking about with the administration and the stakeholders in the last.
All right, do we have language on
6 hours
on going out for an RFP? Is there language on that? Okay. There's a second sub. It's not before us, but we're going to try to incorporate those portions of the sub into this bill, okay?
Mr. Chairman, while that's being done, can I ask a question?
Yes.
For Mr. Murray.
Senator Cosgrove.
Sir. Mr. Murray, as you know, in the city of Chesapeake, we have a very large coal ash deposit. Is that in any way, shape, or form considered under removal?
Senator, with regard to Chesapeake, and I apologize if I don't get my terminology exactly right, it is primarily the legislation in front of you is dealing with impoundments. So of the ash at Chesapeake, a small subset of it is in what would be considered an impoundment, and that's actually the language we have here on being able to move forward with impoundments where we're recycling the ash. That's that small subset of the total ash at Chesapeake that would be considered an impoundment under this legislation. That's what we'd like to be able to continue to move forward with regard to recycling, and then ultimately maybe closing out that pond if it were DEQ's will, looking at the regulations and looking at the application to grant the permit. The much larger volume of ash there is, and this is a non-legal, non-environmental term, it's essentially a peninsula that was constructed using that as a building material. And this legislation, my quick look would not speak to that. That, as you know, is the subject of some continued litigation, and I think the goal here is not to change the posture of any of the litigants there, but to deal with the deal with a small subset of ash that is in the impoundment that is being recycled, and I'm not aware of any particular controversy on that subset of the ash
All right,
there.
Mr. Chairman, further question.
Senator Cosgrove.
We have 3 million tons of ash. Is that about right in that Chesapeake?
So,
All right. How much ash is in the area that you're talking about recycling?
my recollection is it's tens of thousands of that. It is a small fraction of that.
All right, and the final question, Mr. Chairman.
What's the location,
Senator
John?
Cosgrove.
John, what's the
Well,
location?
hang on a minute, Senator Sproul. Senator Cosgrove has the floor. Senator Cosgrove.
I'd ask Mr. Murray, obviously, I'm very concerned about the ash pile in Chesapeake. Okay, so that will be included in anything that's studied as well.
Oh, absolutely. We would
There-
study.
It's
Right.
not going to be discounted or taken out or withdrawn. Is that your understanding?
My understanding is what this legislation, if in concept has been described here for you, would allow to the extent there is active recycling going on at Chesapeake, that would be allowed to continue. And that as part of our look at recycling, we would look at all 4 sites, Chesapeake certainly being one of those 4 sites.
All right, thank you, Mr.
And
Chairman.
we would look at all of them equally.
All right, thank you, Mr. Chairman.
Yeah. and the
Okay,
subsites.
let's get, Senator Sproul, you were next.
Yes, thanks, Mr. Chairman. I was trying to follow up on Senator Cosgrove. The part that you're going to do, what you're not going to do, I'm trying to find out the location. Where about the tens of thousands that you are going to recycle out of the ground, do whatever? But that's the part that you're not going to touch right now. So what location are we talking about?
There's what's called, I believe it's called a bottom ash pond at Chesapeake, where we've been doing, have been working to do some recycling of that small subset of the ash. And this would allow, to the extent we're already doing recycling, this would allow that to continue. So that would not change anything that we're currently doing there, nor would it prejudge anything that is the subject of ongoing litigation.
Mr. Chairman.
Okay,
Could
Senator.
I clarify that? Could I clarify for that?
Senator Stewart was
Okay.
next.
All right.
Senator Stewart.
Thank you, Mr. Chairman. And I don't know if this is a question somewhat, but then I think an important consideration, and maybe Mr. Murray can correct me if I'm wrong, but I've agonized over this because I represent part of Prince William County, and obviously we've got Possum Point, and if you look at moving all that coal ash in that pond, that's a tremendous undertaking for right many years. And so all the roads are clogged up, and I mean, it's just a tremendous undertaking at a tremendous expense. I understand, and maybe somebody can help me with this, if you recycle it and make bricks out of it, and you have to move it to do it, or even if you recycle it on site, and then you have to reburn that coal ash. And so essentially you could be reburning carcinogens in the vicinity of where it is now. Is that accurate?
Senator, I've got to apologize that I'm not an expert in the recycling process. We can certainly make those experts available to you either in this committee or in the committee that you chair. Having said that, what we would do if we were asked to look at taking bids for recycling, we would take last year's analysis that we did and really sort of sharpen our pencils on the recycling part of that. A lot of what you're describing was analyzed in the report last year's legislature asked us to do. If you all are sending us a signal that you'd be particularly interested in some additional analysis on recycling, we'd continue to do that analysis. We would not view what's in here as limiting, that we would only accept bids. We'd certainly look at all the pluses and minuses in recycling and try to keep whatever study vehicle you all set up, or if not, or the standing committees, well informed, so that you could make further policy choices down the road.
Mr. Chairman,
Senator
thank you.
Stewart.
I don't know what I think is best yet. I really think this is a hard choice. It's expensive. There are risks and burdens associated with each. And I guess what it would boil down to is, in this study, I think it's important that we have input from the people local to this that would be affected. And I think we ought to incorporate that, Mr. Chairman.
All right, Senator Stewart, let me tell you the posture I think we're in right now. We have some parts of the substitute that Senator Serville had that we would roll in there, and that would be, I believe, of your substitute, Senator Serville, Senator 8 through 21 is already covered under our subsection 4.
8 through 22.
8 through 22 is already covered by what our language in 4.
Right.
And a lot more condensed and easy to read. Sections 2 and 3, I would make, what's that? 5, I'm sorry.
Yep.
5, not 4, 5. So sections 2 and 3, I would propose the amendment that we put sections 2 and 3 into my substitute, okay? And move forward with that as our.
Can I also say, Mr. Chairman,
Yeah.
that the only part of your bill that is needed is section 5.
I know, and I'm going to make that next, okay?
Okay, all right.
All right? So it's been moved and
Second.
seconded that the number 2 and 3 from Senator Serval's bill be put into the substitute we're working with right now. All those in favor say aye.
Aye.
Aye, okay. Now, the next amendment I'm going to make is that we strike sections 1 through 4, which starts on line 608 and ends on line 629 for my amendment, just to get in the right posture. Is there a second?
Second.
Okay. Moved and seconded that language be stricken. All those in favor say aye.
Aye.
Okay. Let me tell you where I think we're at right now, okay? We are going to continue to delay the issuance of any permits until 1 July 2019. We also are going to allow DEQ to issue permits to close the ponds that are already cleaned up. Okay, issue final permits on that.
Correct.
We are going to direct Dominion to go out and seek RFPs on recycling so that we have a lot more information about the costs, what we're looking at, what can be done, what can't be done, and move forward with that language so that we have a lot more information. In tandem to that, I will, and Delegate Kilgore, the Chairman Kilgore, and the House is already set up, and I will designate a committee off this Commerce and Labor Committee, probably including some of the patrons of the bill, to be on that study, to work in tandem as we sort through this on possible solutions for these coal ash problems.
Mr. Chairman,
Yes, Senator Dance.
I surely would like to be added because I've been real quiet as they've discussed all of this because the coal ash pond in Chesterfield County is in my part of the district, but I'm listening. Thank you.
Mr. Chairman. Thank you. For Mr. Murray. Thank you, Mr. Chairman. Mr. Murray, just to alleviate Senator Spruill's concern and some of mine as well, when we're talking about the Chesapeake coal ash area, what you described as ongoing recycling activity, is that co-located with the larger pile right on the Elizabeth River?
It's the bottom ash pond. Let me look at my friends here to see bottom ash right now. It's the bottom ash pond, which is a small subset of the overall facility.
But it's
It's
right in
the
the
former
same-
power plant site.
It's right in the same area. as the
Yeah,
power plant.
it's what we used to call Chesapeake Energy Center when it was an
And
active coal
my
plant.
last
Yeah,
comment, Mr.
Senator
Chairman.
Cosgrove.
Ladies and gentlemen, this is very, very important to us in Hampton Roads. This coal ash depository sits on the southern branch of the Elizabeth River, which is less than 10 nautical miles from Chesapeake Bay. Heaven forbid there is a natural disaster, probably a tornado. Lord knows we get our hurricanes. We're concerned about that. We're concerned about having the same kind of spill that Duke had. And so I'm glad this is going into study. We can look at all of that and try to get some peace in the valley and some understanding.
The one distinction I'll make, Senator, is 3 of these 4 sites, primarily the majority of the ash at one time was in water in what was called an ash pond.
Right.
And while there was an ash pond at Chesapeake, it was a small subset of what was involved in ash landfill.
Right.
So that while I absolutely understand the concern and the sensitivity of the site, the exact facts of the Duke situation would be more related to something where the ash is stored in water.
Right.
And that, as I understand, the overall federal rule that we're trying to comply with, the whole point of the overall federal rule was to not have situations where ash was in water that might be then get into an ambient water body because of an impoundment break.
All right. Thank you, Mr. Chairman.
All right, thank you. All right, we have the bill and the posture it is. Is there anyone that would feel compelled to speak on this? Michael, is there?
I'm good.
You're good, okay. There's peace in the valley. Yes, yeah, okay, yeah.
Mr. Chairman, to confirm what's going to be reported as a substitute by this committee, it's going to be a Section 1 bill comprised of what was your fifth enactment from your substitute, and then the second enactment and third enactment will be Sections 2 and 3 of the shorter substitute that Senator Surville offered. Is that
Got it.
correct?
And I need to hear from Senator Chase. Senator Chase, would you come up for a minute? Have you followed everything we've done?
Not a thing. No, I'm just kidding. Yes, somewhat. I just wanted to make a couple
Sure.
comments, if I could. Senator Surville and I have been working very closely on this bill, and we're going to work as a team on this. I do want to add some things regarding Chesterfield, because Senator Dance and I have been, talking a little bit about this, and I want to make sure she understands specifically Chesterfield. My big concern with this is that we want to make sure that whatever expense that is incurred, that we are allowed to expense this over a period of longer than 21 years to address Senator Dance's issue of this could be a tremendous cost on the front end in the form of a rate adjustment clause, which we don't want to pass on to the consumer. So if we can have the opportunity to expense that over a longer period of time, I want to make sure that's included in there, because I support removing the coal ash. I want it to be gone. I mean, we're talking in Chesterfield about the coal ash. There's no liner between the coal ash and the ground. And you're talking about hexavalent chromium and arsenic and all these other dangerous materials. I want it out of my floodplains. There's one in Chesterfield. I want it away from the river, which is within just a couple feet away. I just like to see it all removed. And that's, I think, overwhelmingly what I'm hearing from the constituents in my district. And so if we turn this into a study, I just want to make sure we're studying the right thing. We just got an 800-page document from an independent study. And I know in that it included a lot of things that required cost for barging, cost for trucking, and a lot of things that I think would actually create a second public safety issue. I don't want to do that. I want to make sure we're not creating a second public safety issue with flying coal ash and all those trucks. Senator Dance and I don't like that. But if we have this on site, if at all possible, whether we're doing brick kills, whether we're doing the, it's basically cap and seal in place, but in a way where you're actually protecting the ground as you go. I think it's called encapsulation. And I just equate it as a mom into putting all the coal ash in Ziploc bags. But my main goal is I don't want that coal ash touching the ground, and I want to do it in a cost-effective way, so we're depreciating that cost so that it's not so expensive over the long term. And that's my hope and my wish.
Question to her.
Senator Sproul.
Let me ask you a question. I'm hearing what you're saying. Why are you saying that if this was a problem that was created by the company, why are you saying that you want to extend it a long period of time, and why you want the customer to pay for something that they did? And if it was something that was created by the customer, this flyer stuff was not done by the customer. It was a mistake, we assume, on their part. So why are you asking that the customer to pay for a mistake that they did? And then on a long period of time, when you say that, we have no idea when it's paid for and how we know when it's going to stop. So I'm just trying to figure out, why should the customer pay something that the company did themselves that is wrong? They got to clean it up, and you're going to ask the customer to pay for something that they did. They got plenty of money. Why can't they do it themselves?
Senator Sproul, I couldn't agree with you more. And in fact, I asked that very question a long time ago, and here's what I've come with after doing some research. Dominion has not always owned this problem. VEPCO's been around before them. And anybody that uses electricity, we're all part of the problem. We created the coal ash. Anybody that has turned on a light switch is part of this problem. And so the State Corporation Commission gives Dominion the ability to recoup their cost through a rate adjustment clause. Now, I would love for Dominion just to pay for that. That would be great. But, and if they want to do that, I mean, we're certainly open to that.
Okay, we're getting way, way off point
But-
about, nobody's talking about rate adjustment clauses here. Nobody's talking about payment here. What we got right now is a bill in front of us that talks to allowing Dominion to get a permit to close existing ponds, keeping the moratorium in place and continuing ahead with a study where all of this that we're talking about right now will be vetted out. And with that,
Mr. Chairman,
yes, Senator Servo.
sorry. First of all, Prince William County is here, and they just also wanted to make sure that it was known that localities also might want to have a voice in whatever process there is. Number one. Number two, STLC had a clarification on the Chesapeake situation. I don't know if the committee's interested in hearing that really quick.
No, we have a bill in front of us,
Got
and
it.
I told
I
you,
got it.
I
You're
got
trying to
20,
move the
I got
docket.
20
I get it.
minutes, and I got to chair another committee.
Got it.
So
Okay.
we know what's going to happen. Let me just say this right now, Senator Chase, I can carry your bill over, which allows you to come and be part of the committee, because you're not a member of this committee right now. Or I can roll your bill in with Senator Serville, and you can be chief co-patrons. Your choice. You want me to carry over so you can attend the meetings as a member, or do you want to be chief co-patron of the bill?
I'll be chief co-patron with
All
Senator
right,
Servo.
all right. With that, the chair will entertain a motion to roll Senate Bill 708 from Senator Chase into Senator Serville's, what did we decide that was? 807. Okay, 708 and 807. So it's been moved and seconded that Senator Chase bill be rolled over. All those in favor? Say aye.
Ayes 14, noes 1, 1 abstention.
Okay, the bills are rolled together. Committee operates by
Mr.
motion.
Chairman, you need to roll my other 5 or strike them.
I'm going to refer the rest of your bills into the study.
Got
Okay,
it.
all right. All right, committee operates by motion. Couple people want to speak? Okay, come on.
Mr. Chairman, we got a motion. Second.
I make a motion that the bills be passed by for the year and referred to committee of which you speak.
Second.
Oh, the remainder bills. We're not on that. We're on this bill right now, so don't get me out of order. We have not acted on 807 and 708, and we're going to report that bill. Yes, sir, briefly.
Very briefly, Nate Benferrato at the Southern Environmental Law Center. I just wanted to correct a few things about the Chesapeake site. For 30 years, Dominion was sluicing coal ash wastewater into these 3 settling ponds that are collectively referred to as the Horse Historic Pond. Those ponds still exist. They contain 2.1 million tons. A federal judge has already ruled that those ponds are discharging arsenic into the southern branch of the Elizabeth River. There's no functional distinction between the bottom ash pond, which is Dominion has committed to being dug up, and that historic pond. It's not a landfill. It's an impoundment that should be dealt with the same.
Thank you, and it's still under litigation, my understanding. Yes, sir.
Robert Crockett Devanis for Prince William County. Appreciate the comments from Senator Stewart. We just want to make sure the localities are considered when you go through the study.
Absolutely, thank you. Okay.
Mr. Chairman,
This
one
is
last, I have 2 constituents here, the Marrows. They don't have to speak. I just want to acknowledge they're here. They live
Oh,
next to the pond.
if
They've
they
been
would,
severely
stand up,
affected.
please. Let
Right
me-
here.
Thank you all for coming. I do appreciate it. This is, believe me, a step ahead of where the House is right now. Okay, we have some legislation moving forward. The House had rolled everything into the study. So keep that in mind. It's going to be all we can do to get this bill out of the House when we take it over there, okay? It's a step. Okay.
Thank you, Mr. Chairman.
Okay. Committee operates by motion. Been moved and seconded that Senate Bill 807 and the amendment in nature substitute be reported. Clerk, open the rolls. Okay.
Ayes 13, noes 1, 1 abstention.
Okay, and the chair would entertain a motion to take Senate Bill 765, 766, 767, 768, 808 in a block, and carry those bills over, and I'll refer them to the study committee. Is there such a motion? Been moved and seconded.
Second.
Those bills be carried over to next year. Clerk, open the rolls. Okay. Hang on.
Ayes 15, no 0.
Okay. All right. Did we do Senator Peaks? Thank you, Senator
I
Servo.
still have that other consumer finance bill.
Senator Peak. Senator Chafin,
Yes, sir.
you have 2 bills today.
Chairman have any preferences to the order of those bills?
I'm sorry?
Any preferences to the order of those bills, Mr.
Your
Chairman?
pick.
Okay. I'll just take them in the order that they're numbered then, Mr. Chairman. Senate Bill 388 it pertains to the Virginia Life Accident and Sickness Insurance Guarantee Association, which was statutorily created, and it has a board, a governing board. This bill simply changes the range of board members from the range right now is from 5 to 7 board members, and this bill seeks to change the range to 9 to 13 members. And the recent insolvencies have primarily involved companies that write long-term care insurance, and with this change, the board would be able to, there would be board members able to serve on the board that represent those companies that are subject to those assessments for those long-term care insolvencies.
Okay. Are there questions for the patron? Is there anyone opposed to this legislation? It's been moved and seconded that the bill, Senate Bill 388 be reported. Clerk, open the rolls.
This ain't gonna work.
Up. I know. Oh. $6.25. We haven't taken it.
I'm afraid that could be Senator Saslaw. Maybe we could do this at your desk tomorrow.
Okay. Yeah, the motion is to report.
Would you vote me, Dick? Vote me for my bill.
Okay. Clerk, close the rolls.
Ayes 14, no zero.
Okay, that bill. Senator Chafin.
Yes, sir. Mr. Chairman, Senate Bill 974 deals with deals with action of corporations without a meeting. Now, the standard process for shareholders of a public corporation is to act in the corporation's annual meeting or special meetings, as they may be called. And that process allows for deliberation and gives both minority and majority shareholders a voice in the process and the ability to deliberate and share their views. There's another option for shareholders to act outside that process with unanimous consent and with unanimous written consent. However, there was a law changed in 2007 that allowed a majority of shareholders to act outside the meeting process if only the majority agreed. So this bill is designed and brought to address that process, which potentially disenfranchises minority shareholders of the opportunity to be heard. So my legislation tries to balance the use of written consents with the interests of the minority shareholders. So if a minority shareholders representing 30% of the outstanding shares in a public corporation have the ability to call a special meeting, then the majority consent provision is not necessary. The special meeting will allow for the issues to be discussed by that group. There's also a grandfather clause in this that would exempt this rule from any companies, and this is important, that already have these rules in place.
Okay. All right. Does everyone understand the bill? You have an amendment? We have some technical amendments, clerk report?
There are some technical amendments.
Mr. Chairman, in order to fix the title, if you look at line 3 of the bill, after relating to, we should insert stock corporations, semicolon, and then after action by, strike with a and insert shareholders without.
Okay. You proposing those amendments?
I move the amendments.
Is there a second?
Second.
Been moved and seconded, those amendments be agreed to. All those in favor say aye.
Aye.
Any opposed? Okay, those amendments are before us. Is there anyone opposed to this legislation? Is there anyone for this legislation?
Move to
That,
report.
we got it, okay.
Move to
Been moved and
report.
seconded that Senate Bill 974 is amended be reported. All those, clerk open the rolls.
Thank you.
Ayes 14, no zero.
Okay, Senator Servo, we gave you a little break. You're back up.
Thank you, Mr. Chairman, and I know you're short for time, and I'll try to be respectful of that. This is Senate Bill 625, which the committee previously heard reported 12 to 2, I think. So this has to do with consumer finance companies, and I'm going to hand out a list from the State Corporation Commission of all the consumer finance companies in the state, just so you can get a sense of who we're talking about and where they're located. But as I think the committee knows, the Bureau of Financial Institutions issues different licenses for different kinds of lenders. There's banks, there's credit unions, savings institutions. We created motor vehicle title lenders in 2010. There are payday lenders, and each of them has a separate license. They stay in their own lane. Consumer finance lenders, consumer finance companies are another license that's existed since 1918, 100 years now. And this list you're getting is a list of these companies have been doing business for 100 years. As far as I know, I don't know of any legislation or unhappiness with the way these guys have been doing business. No complaints, no bills, no legislation, none of the talk about predatory loans or anything like that with consumer finance companies. What's happened is these internet lenders have shown up on the scene now at the advent of the internet. And the Bureau of Financial Institutions wants to try and get internet lenders under some kind of regulatory regime. And right now, they don't fit anywhere. They're not mentioned anywhere. In order to be a consumer finance company, you have to have a brick and mortar location. You cannot make a loan only over the internet. You have to have brick and mortar. Consumer finance lenders, they lend money to people at lower interest rates, people that have good credit. They have a completely 100% different business model than these internet lenders. And as part of the discussion about regulating internet lenders, the BFI started talking about putting internet lenders into the Consumer Finance Act, putting them together, these two completely, totally different businesses together. The consumer finance industry, the people whose list is right there in front of you, don't want to be in the same box with these people because they have completely, totally different business models. And so they came up with this legislation that reflects their business practices, what they do in their industry, and they're totally comfortable with it. Mr. Smith is here to testify on behalf of the Virginia Financial Service Association. But what this bill does is it basically puts a 36% rate cap on the consumer finance industry. All these companies that are there in front of you, they're okay with that. They don't make loans for more than that. It raises some fees they can charge. It makes it clear that anyone who has a payday license or a car title license cannot use this license to make loans as well, and I don't believe there's any problem with that out there that I've heard of. That's pretty much, it makes a couple other changes to modernize a couple fees they can charge here and there. But that's all this bill does. Chairman Kilgore has a bill in the House. We're not supposed to talk about what happens over there. And my bill is getting all mixed up with that bill. And I wish it wouldn't, because my bill is not his bill. And that's why I said on the floor, if the internet lenders want to get a bill, tell them to go get their own bill. But I don't want their bill to become my bill. And so that's what this does. And we passed that here 12 to 2. The industry wants it, and I think we ought to pass it as is. I'm happy to take any questions.
Questions for the patron? Okay, is there anyone that wishes to speak for the bill? Briefly.
Mr. Chairman, I'm Jeff Smith, Virginia Financial Services Association. Well aware of the speed limit you've set, Mr. Chairman. We don't want, as an industry after 100 years, to be thrown into the same basket of legislation that you have to deal with annually now on rates for payday, title, revolving, and internet. And if we don't pass this bill, which is currently deregulated, and put us back in the pre-deregulated structure that we had before, you've added the consumer finance industry to this bucket that we don't want any part of. Thank you.
Thank you. Others in favor?
Mr. Chairman, members of the committee, Kevin Maurer, Virginia Catholic Conference. We do support the bill. We hope you report it once again to close this loophole in Virginia's anti-usury law. Thank you.
Thank you. Yes, sir.
Mr. Chairman, Dave Irvin with the Attorney General's Office, Consumer Protection Section. The Attorney General supports the bill for the same reasons we stated at the last meeting.
Thank you.
Thank you.
Yes, sir.
Jay Spear, Virginia Poverty Law Center. We support the bill.
All right, thank you. All right. Is there opposition to the bill?
Mr. Chairman, members of the committee, Edward Mullen with Reed Smith on behalf of the Online Lenders Alliance, and I appreciate the opportunity, and I will, too, be very brief. Senator Survell set up the situation nicely, and it is an odd situation because on its face, this bill does not apply to online lending. But, and this is very important for context, if it's combined with the BFI stakeholder bill that Chairman Kilgore is carrying, it does apply, and it's to devastating effect because that bill has the effect of bringing internet lenders into this framework, and if you apply this rubric to that, that's very difficult for the online industry. That may be the point of this bill. That bill, just so you know, is the result of a year-long process with give and take that requires internet lenders to, among other things, become licensed, comply with consumer finance laws, file with the Commission, submit to BFI for oversight, and submit to the Attorney General's Office for enforcement. In short, it brings internet lenders out of the ether and into a licensed and regulated structure, and that's a good thing. A key provision in that discussion over the course of the year that was considered but not taken up was a rate cap, and that is obviously a key feature of this bill, although this bill has a number of exemptions and fees that are added on to the rate cap. And while online lenders do not take collateral, such as cars or paychecks or garnish wages or upsell ancillary insurance products or anything like that, they do have rates that are in excess of the rates that are in this bill, and that is the difficulty. Certainly open to continued stakeholder dialogue, but submit that a rifle shot in this way in a vacuum that would be applied if that other bill does proceed would be the wrong approach, and I respectfully ask for the committee's consideration to either carry this bill over or pass it by, and any consideration on the issue being taken up if there is a bill that comes over. Thank you, sir.
Thank you. Are there questions?
Mr. Chairman,
Senator Chafee.
I have a comment. It's not a question. I just have a comment for the bill. I put up a no vote for this bill when it was last considered in committee, and since that time, I've learned more about this industry that is impacted, and I've now learned that the statement that these are different types of industries is accurate, is exactly accurate. They have different types of services that they offer. They have different types of customers that they have. They have mortar and brick. They have locations that have been in existence for many years. The regulation of the two, in my opinion, should be distinct. It should be separate and distinct, and therefore I intend to support the bill today.
Okay.
Second.
It's been moved and seconded that Senate Bill 625 be reported. Clerk, open the rolls. Close the roll. Oh, sorry.
Ayes 14, noes 1.
Okay. Senator Survell, we'll see you next year. I know. All right, Senator Peake.
Mr. Chairman, that would be one of his 10 bills next year.
Yeah. Senator Peake, yeah. What do you got? 346.
Thank you, Mr. Chairman. Good afternoon, members of the committee. That's a very simple bill here. We are not asking for any money, does not need any appropriation. We are just trying to add a little language to allow fire departments to use money that they already have in their possession to buy equipment to help fight cancer. So it's protective equipment and decontamination equipment to help them with cancer prevention techniques. And so no money, Nothing new. We're just adding that list of equipment to what they can buy.
Okay, are there questions for the patron? Is anyone opposed to this legislation? There's amendments. Clerk, report the amendment.
Mr. Chairman,
Where's it?
Senator Pake's office caught an error which requires an amendment on line 58. After diesel exhaust, insert the word removal.
Removal systems, yes.
Okay. Committee understand the amendment. I hear a motion on the amendment. Been moved and seconded that the amendment be adopted. All those in favor say aye. Any opposed? Okay, the bill's before us. Senate Bill 346 is amended. Is there a motion?
Move to report.
Been moved and seconded. Senate Bill 346 be reported as amended. All those in favor? Clerk, open the rolls.
All right. Thank you, Mr. Chairman.
Thank you. All right, I have the last bill, and we will try to be as brief as we possibly can. If the committee would pay attention to Senate Bill 661. What Senate Bill 661 is, it looks back in and in the payment of wages section of the code, it removes exemptions that include newsboys, shoe shine boys, ushers, doormen, concession attendants, and theater cashiers from the Virginia Minimum Wage Act. We think at least those folks ought to be exempt from the Minimum Wage Act. It talks to excludes babysitters limited to those not employed more than 10 hours a week, and still exempts the spouse, children, and parents of an individual employer excluded for purposes of definition. The measure eliminates the Act's exclusions for persons employed by an employer that does not have 4 or more employees. The measure requires a court to award attorney's fees incurred by an employee who is awarded a judgment in action for violation of this Act, and the measure expands information employers required to provide employees when wages are paid. It gets to the issue of employees working and not getting paid. That's what the bill does. I suspect there's people who would like to speak for the bill and against the bill, so I'm gonna have to put you on the clock, 3 minutes each. Those in favor?
Thank you, Chairman. I'm Kim Bobo. I'm the Executive Director of the Virginia Interfaith Center for Public Policy. I'm also the author of a book called Wage Theft in America, so I know a lot about the issue of wage theft. It is a common problem in Virginia where workers work and don't get paid for all their wages. This is a very simple bill that removes some of the Jim Crow exemptions that exist in the law. It allows employers that have small workforces to pay workers. It requires them to pay minimum wage. And then it makes a few minor improvements in terms of enforcement against wage theft that really is good for workers and for employers that pay businesses that pay fairly as well. So we think this is a really important bill, and thank you, Senator.
You, Kim. Thank you. Others? Yes, sir.
My name is Robert Field. I'm with Virginia Department of Labor and Industry, and the governor supports this piece of legislation.
Okay, thank you so much. Any others? Okay, those opposed?
Mr. Chairman, members of the committee, Nicole Raleigh with NFIB. We still have some concerns with the bill, mostly the ones dealing with the paperwork requirement, dealing with like hours worked. This could really actually impact employers who use independent contractors. They probably most likely do not indicate that kind of information. So there could be a lot of small business owners, particularly those who don't have HR departments, having to deal with this burden regarding the pay stubs. And then also by opening up the investigation from off of one complaint to all employees, we really feel it does expose a business to more investigations, and that we feel that there are already adequate protections for folks to make their complaints. Thank you.
Thank you.
Mr. Chairman, members of the committee, Ryan Dunn with the Virginia Chamber of Commerce. Echoing what Nicole Riley just said, we have concerns about the change from the may to the shall. There are few claims for unpaid wages that are made relying on the Virginia Code section. Nearly all claims are brought in federal court relying on the FLSA because for liquidated damages as well as attorney's fees. So that's a big change there. And then the 2 years look back is also a problem that we have a little bit. So for those reasons, we oppose the bill.
Thank you.
Mr. Chairman, members of the committee, Jody Roth on behalf of Virginia Retail Federation, and we also oppose.
Okay, I think everybody understands. We've heard the bill before. The committee operates by motion. Do I hear a motion? been moved, and do I hear a second? I'll second, it's my bill. Okay, it's been moved and seconded, the bill be reported.
Substitute motion.
It's substitute motion,
Gently, PBI.
extremely gently.
Very, very, very gently.
Pass the bill. Is there a second on that motion? Okay, second gently. Okay. The substitute motion is before us, and that motion is to pass the bill by gently. Clerk, open the rolls.
Ayes 9, noes 5.
Okay, the bill has been passed by, and with that, we have completed the docket. I just want to thank the committee. We've worked some long, long hours in here and had a lot of big issues this year. I really appreciate all the support and everybody on the committee. Committee will rise.